here we go. Here's our study guide for CivPro, and I'm just going to dive right into it. Terms. Common law is case law. They're the same thing. Judicial review. Process by which higher court reviews conflicting statements of law on an issue or reviews a statute declaring it unconstitutional. Concurrent power. Fed and state legislatures both have power to legislate on the same subject or legal issue and are both valid. However, higher court can preempt the lower. Substantive law defines legal rights and obligations. Procedural law sets forth the rule which must follow to enforce those legal rights and obligations. CCP is California Civil Procedure. CRC is California Rule of Court. FRCP is Federal Rules of Civil Procedure. Trial de novo is an appeal to the Superior Court. Civil litigation is lawsuits between individuals or entities. It just sounds like Linda Blair is going to sue the demon that possessed her or something. Purpose of pleadings. Due to process notice and defending of the self. Purpose of pleadings. The reason I would plead would be to, follow the rules of due process. And, notice and defending of self. Okay, so you plead to defend yourself, basically. At issue. Oh, right, so it's a due process, meaning you did it in time, and notice, meaning you gave notice in due process, meaning you did it in the right time frame to defend yourself, pleading on time. At issue. Status of case upon filing of an answer. Okay, so once you filed your answer, it's at issue. Pre-litigation, first client contact. Attorney decides cause of action, what and when to file. The statute of limitations, it goes as follows. Triggering event, tolling. 1 year, slander, libel, false imprisonment, forged checks, actions by good faith buyer. 2 year, personal injury, assault, battery, wrongful death, actions to oral contracts. 3 year, trespass on, injury to real property, actions based on fraud or mistake. 4 year, written contract, actions. 5 year, real property actions. Whom to name. Standing equals actual case or controversy, real party of interest. So that's the standing. That's the actual case or controversy, real party in interest. Whom to name. Injured minors, class action, environmental protection suits, child support, defendant, spouse. Capacity is the same thing as, capacity means to sue or be sued. Age of majority, competence, exceptions, minors 12 plus, emancipated minors, corporations suspended, foreign, out of state, probate or trust estates, building contractors, fugitives from justice. Wow, we can name a lot of people. DOE offendants, misnames a defendant, does not know the true name, knows names but may not have been acting alone, does not know all facts upon which liability is based. So it's kind of like holding places for Mr. Wetchamahooits and all of his friends in case you should need to call them into court. Joinder of parties. Bringing together of different parties into one lawsuit. Compulsory, permissive. Okay. Where to file. Subject matter jurisdiction, type of case, general, criminal felony, civil cases with damages, 25,000 plus, unlimited in brackets, involving filing fees, allowable pleadings, limitations on formal discovery, juvenile cases, family law, mental health, probate, estate cases, guardianship, conservatorship, appellate cases, limited jurisdiction, criminal misdemeanors, civil cases with damages, under 25,000 limited, small claims, traffic, amount in controversy, concurrent jurisdiction, either federal or state, federal, constitutional question, diversity jurisdiction, personal jurisdiction, in personam, in rem, quasi in rem, venue, equal geographical location, where defendant resides, where injury occurred, where contract into, where property located, forum convenience, seriously inconvenient for parties. But this was all under the caption, where to file. That's some really serious poetry. I did it in my best interpretational voice. Identifies area of law. Okay. Other issues, relief to seek, declines, conflict of interest, Chinese wall, lack of merit, mandatory arbitration, inappropriate for firm, monetary reasons, personal reasons. These are reasons you could decline a case, I'm assuming. Draft complaint. Initiate lawsuit. Okay. Contains caption. Name, address of attorney, comma, bar number, firm, telephone number, fax, email, body, venue, allegations of jurisdiction, general facts, summary, specific facts, elements, perimeters of discovery, ultimate facts, prayer for relief, damages sought, subscription, verification, signed by attorney. Summons. Mandatory judicial counsel form. Notice to defendant they are being sued. 30 days to respond. What happens if failed to respond? Prepared and submitted with complaint to clerk, signed and stamped with date. So a summons includes a mandatory judicial counsel form, notice to the defendant they are being sued, and that they have 30 days to respond, and what will happen to them if they don't, and it has to be prepared and submitted with complaint to clerk, signed and stamped with date. Service of process. Plaintiff serves on defendant. Personal service equals effective date served. Substitute service. After diligent attempts to personally serve, leave with member of second copy mailed to same address as served. Effective date equals 10 days after copy is mailed. 60 days to file proof of service, summons, or return of summons with court. 30 days for defendant to respond. I'm seeing I missed a little thing up here. I'm sorry, I'm backtracking. Under service of process, in the same line where it says, after diligent attempts to personally serve, leave with member of household or business. I'm so sorry that I had to backtrack there. But that's under services process. Okay. Let me just backtrack then. Service of process. Plaintiff serves on defendant. Personal service equals effective date served. Substitute service. After diligent attempts to personally serve, leave with member of the household or business. Second, mail copy mailed to same address as served. Effective date is 10 days after the copy is mailed. 60 days to file proof of service of summons or return of summons with court. 30 days to defendant to respond. Service of mail with acknowledgement of receipt. 2 copies with acknowledgement of receipt and self-addressed stamped envelope. Effective date equals day acknowledgement. Signed. Service by publication. Court granted after due diligence. It says CT granted after due diligence. Published in newspaper once a week for 4 successive weeks. This is service by publication. Effective date is the last day of publication. Outside California, any above methods and certified mail with returns receipts. If defendant fails to respond, can submit a request for entry of default. Requires proof defendant was properly served. Proof that required time for responding has run out. Defendant failed to respond or appear. Cannot be entered against defendant in military involving plaintiffs against DOE defendant, as in doe, a deer, a female deer. after entered, a default judgment may be sought from county clerk. If case seeks recovery of money or damages in fixed or determined amount / limited to amount requested, summons not served by publication from court. If not damages not ascertainable from complaint, if complaint seeks damages in amount to be proved at trial. Okay. From court, if not damages ascertainable from complaint, if complaint seeks damages in amount to be proved at trial. Oh my gosh. So you can seek default judgment from the county clerk or from court, and that's what all that other information was about. Defendant answer must contain effective denials, appropriate defenses, objections for each cause of action. Several allegations may be denied in single statements. Allegations may be admitted or denied in particular. No negative pregnant. Okay. On pleading paper, included caption, body, format of denials of causes of actions, prayer. Plaintiff take nothing by way his complaint, that defendant be awarded cost of suit and / or attorney fees. Motion to quash summons. Challenges court's personal jurisdiction. Okay, so you can quash something if it's like, this is the wrong court, that's the wrong jurisdiction. Man, you're screwed. Served by unauthorized means. These would be reasons for challenges of jurisdiction. One would be that was served by unauthorized means. Defendant has no contacts with California. Filing constitutes special appearance. Must be done 30 days from service of summons. Extends response time to complaint by 15 days after notice of entry of order denying. Default, no response. Response to default judgment can move court to set aside based on inadvertence, mistake, excusable neglect. Must be done 6 months of entry of default with attorney affidavit of fault, fraud, or mistake. Tiers, lack of notice, or 100 days after notice. 2 years for lack of notice or 100 days after notice. Whoa. Respond, answer. One is admit allegations. This is in big bold caps. Expressly admitted, deemed admitted if not expressly denied, can then be used by plaintiff at trial without offering evidence. Deny allegations. Deny material allegations, does not want to admit. Can reject allegations on grounds they are false. Can be on information and belief. Believe false but not entirely sure. Not enough info to admit or deny. Lack of sufficient info or belief to answer and therefore deny allegation on those grounds. Effective denials are those with appropriate defenses or objections for each cause of action. Inconsistent defenses are allowed. Well, isn't that interesting? Denials can be general or specific. General, only allowed if complaint is not verified, verified no more than 1,000 in damages, used to avoid being tied down to particular fact admissions or denial, may deny true allegations. Specific, deny specific parts, a paragraph, sentence, allegation with a paragraph. Answer must be verified, required when responding to a verified complaint. Assert affirmative defenses. Appear after denials and answer, alleges defendant's actions were justified, or that for one or more reasons plaintiff has no legal right to bring action. They do not attack the sufficiency of the complaint. Stated as independent reasons plaintiff should not recover. They are additional to admissions and denials, even if allegations are true. If they are not satisfied in a timely manner, then they are waived, listed by number with short heading. Begin by intending cause of action they relate to, then defense. Defendant bears burden of proof, must plead using ultimate facts. Examples: denies liability or justifies. That's in torts. Assumption of risk, contributory negligence, self-defense, insanity. Breach of contract, statute of frauds, fraud in the inducement, mistake, estoppel. That's spelled ESTOPPEL, whatever it means. Bar to action. Statute of limitations ran out. Standing / capacity to sue. Protected activities. Privilege. It lacks personal or subject matter jurisdiction. These are all in the category of asserting positive or affirmative defenses. Okay. Attack. A defect is on the face of a complaint when it is evident from the construction of the complaints without further investigation. Non-waivable grounds: lack of subject matter jurisdiction, lack of standing, failure to state a claim upon which relief can be granted, procedurally are done by motions. Processes: complaint, attack with arguments, opposition to attack, reply to opposition. Court reviews with or without hearing, then sustains or denies, overruled. Respond to complaint as drafted. Sustained is pleading. Overruled equals respond to complaint as drafted. Sustained equals pleading can be amended to cure flaws. Okay. Cons of attacking: time, money. Judges unsympathetic to delays can educate plaintiff to their weak points and make harder to defend. Pros of attacking: focus of or define an issue, force plaintiff to prove validity of his case, set tone for litigation as adversarial. I think it's time to stop. Nope, I'll go through demur. Pleading in form of motion raises issues of law, not fact, constitutes general appearance, requests judicial determination as to legal sufficiency of complaint, cannot be brought forth without first having and meet and confer. On technical grounds, does not have cause of action, or one or more elements of a cause of action is missing. Can be total or partial, entitled complaint, or just one or more causes of action. Wrong party named, brings judicial notice to things that are clear without need of research / common knowledge of indisputable facts, does not challenge truthfulness, assuming allegations for true purpose of demur is not an admission. Okay, this one's done.